Welcome everyone to Washington Arbitration Week, third edition. And this is the how to do's on ICC arbitration clauses. And this particular session is actually was designed especially by ICC YAF. So everyone here, especially Mary-Kate and Diogo and Marek and the team of ICC in New York. So we're really glad that we are collaborating with ICC YAF. We're also very grateful to Mark Simrod and to Ken, to Mary-Kate and all the partnership and attorneys here at Baker Hostetler. I had a chance of working, meeting Mark in other endeavors. So it was a really positive encounter. So we're really grateful that you're supporting Washington Arbitration Week to create a community of lawyers that meet uh, not only in Miami or meet in Milan or in New York, but actually of lawyers of Washington D.C. who meet in Washington D.C. So that's the first thing as I was talking with Lise. Um, the my function here is to welcome the panel and introduce the moderator. I would also like to introduce the representative of ICF in Washington D.C., Diogo Manuel Pereira. He is an international lawyer specializing in international arbitration, public international law, and investigations relating to corruption, money laundering, sanctions, and terrorist finance. He's also an ICCF representative, as I said. Um, and one thing that I missed saying for those of you who might not know me, I'm Jose Antonio Rivas. I had a boutique law firm called Extragy LLP, and 3 years ago, together with Ian Laird, we thought that it might be a good idea to have a Washington Arbitration Week, and we were actually lucky. We didn't think that we were lucky at the time, but we were lucky because the pandemic hit, and that enabled us to have everything online, and we were able to sort of build the name for 2 years. And this is the first time that we're doing this in person. As I was telling in other panels, uh, when we reach out to, when we were sort of programming everything, we thought perhaps we might have 5 or 4 panels in person, and that would be a good goal. And then people started to raise their hands. No, we want 2 or 3, 4 panels. As a result, we're having about 90 or 95%, I would say, in-person panels. This being a very rich one, which we're very glad for. Now, I would also like to introduce Mary-Kate Wagner. She is, of course, together with Diego and others, including Marek and his team, the designer of this panel. She is an associate at Baker Hostetler, where we are, in the International Dispute Group, lending assistance on international commercial arbitration, investment arbitration, and litigation. Mary-Kate spent 5 years as deputy counsel with the Secretariat of the ICC in New York, where she oversaw and managed hundreds of international and domestic arbitrations, including emergency and expedited procedure arbitrations. She's received a JD from Villanova, and she has also an LLM from in French and the international business law from the Sorbonne in Paris. And she speaks fluent French, which you might need to do to use today. So anyway, it's great to be here. It's lovely to have this evening hosted by Baker Hostetler, and with you, Diogo first, and then Mary Kate. Diogo, I hope that you can hear me. Take it away, please.
Yes, can you all hear me?
Yes.
Thank you very much, Jose Antonio, for the kind introduction. And also, Jose Antonio, just to reiterate, ICCF is delighted to be co-organizing this event with Washington Arbitration Week, and we certainly hope it's a collaboration that can continue into the future. For those who don't know, ICCF is ICC's Young Arbitration ADR Forum. It's a group of young professionals, those under 40, from across the world, and basically we set up different events and opportunities for young practitioners to gain skills build their networks, and also to become more familiar with ICC dispute resolution services. So I think across the network, there's almost 30,000 young practitioners. And if anyone here is interested in joining, I would encourage you all to visit the ICC YAF website. There you'll find information on how to become an ICC YAF member. And also you'll have my contact information should I be able to be of any service to you all in that. Today's event is, I think, really typifies what ICCF is all about. So we're going to be discussing arbitration clauses and the do's and don'ts. And this is the sort of subject that can be tailored to law students just as it can for seasoned practitioners. It's relevant for everybody. And we hope that this is an opportunity to bring practitioners and students and seasoned practitioners all together under the ICCF umbrella. So I'd also like to let you all know that in case anyone is interested in helping organize events like this, or if anyone is from a law firm that would like to host events like this in the future, please do reach out to me. Just to reiterate again what Jose Antonio said, we're very grateful for Baker Hostetler's gracious and generous hosting of tonight's event, and we really do rely on law firm partners to be able to host events like this. So I also just want to provide a very brief introduction to some of our remaining our panelists that we already have Mary-Kate introduced. They're all stellar practitioners and academics. And so I won't be going into detail, but I'll just start with Liz Snodgrass. So Liz Snodgrass is a partner here at Three Crowns in Washington, D.C. She has extensive experience in investor state, public international law, and commercial arbitration, and I think she'll be able to share some of that experience today. Anne-Marie Whitesell is the faculty director of Georgetown Law's International Graduate Law Programs, and has also deep and extensive experience in commercial arbitration, public international law, and experience with the ICC as well. And finally, we have Jose Antonio Garcia Cueto, who's partner at Clifford Chance in Washington, D.C. as well. He also has a great amount of experience, and a lesser known fact for you all, he's also a pretty talented soccer player. So if you have any World Cup questions, I'll send those to him as well. And without further ado, I'd like to pass the floor back to Mary-Kate and wish you all a wonderful evening.
Okay, thank you, Diogo. We wish you were here, but we are glad that you were able to join us virtually. So thank you to everyone who showed up today. Thank you to ICC YAF, and thank you to my firm, Baker Hostetler, for supporting not just myself, but ICC YAF. I think it's very important for young practitioners to be able to get together and to create a new generation of well-trained arbitration lawyers. So not to say that the older generation wasn't, but we'll we'll have our chance. So the goal of tonight is to really discuss drafting arbitration agreements. We all know that arbitration is based on consent, but you have to know to what you are consenting. So what we're trying to do is to make sure that when you go before your client, you will produce a clause that will avoid any dispute once you have your dispute. None of us want disputes, but sometimes they do arise in life, but you do not want to be in a situation where you cannot execute your arbitration agreement. So before I pass the floor to Liz, I would like to reiterate that this is an interactive program. It's a workshop. So I have a question for you. And actually, could you put the slides on? Thanks. So how many words do you think the shortest arbitration agreement can be to be effective? No, stay. Dude, don't. Perfect. 2? I'm sorry, how many? 2. Would you like to tell us why you think that?
Because it doesn't make sense, and hopefully you have statistical problems. Because the arbitration agreement is based on consent, and hopefully you have the two parties to consent to arbitration.
So which 2 words would you put in your arbitration agreement?
I do.
Just like marriage. One.
And it will end like marriage.
Why 1?
Because I think it depending on the jurisdiction in which you're practicing, the practice of the courts towards blank clauses and will be different. And I know for my case, I've litigated a case where we enforced an arbitration clause where it was written arbitration.
Oh,
Full
okay.
stop. And that was in France. Thank God, since 2011, blank clauses can be enforced. I mean, obviously, we had to litigate the case and we had to convince a judge that we needed 3 arbitrators in 9. But yeah, one word is sufficient, at least in France.
Wow, good to know. So thank you both. Let's see what our panelists think. Liz?
This is way too high. So I agree that one word is adequate if you've got a supportive jurisdiction. Well, certainly one word is adequate if it in context expresses the party's consent to have their disputes resolved by arbitration. So it's even better if that word is in a section of your contract with the heading dispute resolution arbitration, because then the party's intention is clear. And I would submit that it's even better to have 2 words, which would be something like you see on the screen. Do we have the slides up? Arbitration specifying a seat, or arbitration specifying some rules. And that's because if you have sufficient words, whether it's one or a few more than one, to indicate a clear intention of the parties to have their disputes resolved in arbitration, and you have some indication of, sorry, I'll go back a point. If you have a clear indication of the party's intention to have their disputes resolved in arbitration, then that in and of itself is enough to divest a court of jurisdiction to hear the dispute, right? It may not be enough to get you answers to all of the questions that you then immediately have about how the arbitration will proceed, but it should be enough, if it's interpreted correctly as the party's intention to arbitrate disputes, to divest a court of jurisdiction and leave parties with no alternative for dispute resolution other than arbitration. I think the second word, seat or choice of institutional rules, is important because even that shorthand reference enables you to plug in to a legal framework or a contractual framework effectively when you're incorporating institutional rules, arbitration rules, that allow you to fill in all of the gaps that you might otherwise see in more typical arbitration agreements, which are typically much longer than 1 or 2 or even 10 or 25 or 50 words. And that's important for us to just state right at the outset in case anybody is misled. No one here is advising that anybody advise their client to sign an arbitration agreement consisting of 1 word or 2 words, right? But the point we're making is that given the existence of a well-developed framework of national arbitration law and of arbitration rules that you can by shorthand look into, you can effectively get an arbitration off the ground, probably with a little bit of litigation about it, if one party is resisting, but you can effectively get an arbitration agreement off the ground with a highly economical approach to drafting. So I was asked, in addition to sort of starting with that slightly theatrical framing, to address the question of precision in drafting, right? How much more should you say in your arbitration agreement? How much should you try to legislate for the future? Now, I think almost all of the arbitration agreements I've seen and arbitrated by reference to in an embarrassingly long number of years of practice typically say much more than simply the parties submit their disputes to arbitration. That is the essential requirement, right? The very first thing the thing that any arbitration agreement must have is an unequivocal submission of disputes to arbitration for final and binding resolution. And there are different ways you can express that, but that's the essential minimum. Much more typically, you'll see arbitration agreements addressing other sort of key elements. They'll specify any arbitration rules pursuant to which the dispute is going to be resolved. They'll specify the seat or legal home of the arbitration. They'll typically specify the language in which the arbitration is to be conducted if it's a transaction in which that's something that wouldn't be obvious. And usually, although not always, usually, and I think actually always in my own experience, you'll see a specification of the number of arbitrators, whether a sole arbitrator or a panel of 3 arbitrators. Now, of these, really only the first is essential. Everything else can be filled in by implication. So, for example, if you omit to specify a seat for your arbitration, but you do specify that the ICC rules apply, Article 18(1) of the ICC rules tells you what to do. It tells you that the place of the arbitration shall be fixed by the court. If you omit to specify the language that is to be used in the arbitration, Article 20 of the ICC rules provides that the arbitral tribunal shall determine the language taking into account relevant factors. If you omit to specify the number of arbitrators, Article 12.2 of the ICC rules provides that the court shall appoint a sole arbitrator, save where it appears to the court that the dispute is such as to warrant the appointment of 3 arbitrators. So when it comes to the issue of precision or specificity in drafting arbitration clauses, the reality is that you can actually get away with specifying very little and still end up with an effective and workable arbitration agreement. Much more commonly than the 2-word example we've been talking about to make a point, parties really often do write pages and pages and pages more of language in their arbitration clauses. But my sort of starting point for this discussion is that you really could do a lot worse than to start with one of the model clauses provided by arbitration institutions. And I think we have an example of the ICC standard clause, or a couple of different versions of the ICC standard clause on the slide. Start with that, and then be judicious about what else you might address in the clause. But I think there was a question about this.
Yes, thank you, Liz. So could everyone just take a second and read both of these clauses? And then I would like to know what is different about them. First person to raise their hand gets to answer. Okay, could you?
Well, the first one is a arbitration clause in totality, and the second one is a multi-tiered clause with mediation as one of the prerequisites.
Very good. So this takes us into, should we add mediation into our arbitration agreements? Jose, what do you think?
I'm going to agree with my colleague that this is a weird microphone. First. Second, I will start with bad news. Everything we're going to discuss here typically applies, but then corporate people come, don't talk to you, and you end up with whatever arbitration agreement they copy pasted from somewhere else. And third, yes, I agree with you, sir. It's a multi-tier clause. And do we use them? What are multi-tier clauses? Multi-tier clauses are basically clauses that establish phases or requisites previous to reaching to arbitration. And they have other names. You can call them leak arbitrations. You can call them multi-tier, escalate, multi-phase. There are several words for a same concept. And sometimes I remember what one student told me when I was teaching a class on multi-tier clauses. They are basically like war in Braveheart. First, you go with your horses to the middle of the battlefield, you talk. Can we reach an agreement? Answer is no. You go back, you fight. Well, this is basically the same thing. You set certain parameters previous to an arbitration, and there are multiple types of examples you can do. Here we have mediation, where you have expert determinations, you have dispute boards, you have senior management negotiations, cooling off periods, multiple concepts that refer to the same thing. Do something before going to arbitration. And do we always need multi-tier clauses? The answer is no. It depends on your contract, it depends on your dispute, it depends on what you foresee may happen. But they tend to be quite efficient because you set a stage previous to arbitration in which the parties can try to reach agreements or at least minimize the issues at dispute. And for instance, in construction contracts, it has proven to be very useful. The ICC has extensive documents regarding dispute boards. They have their own rules on dispute boards. And for instance, in that case, the statistics tell you that 90% of disputes are narrowed or settled previous to arbitration. So as you see, it's a very cost-effective way of settling disputes. What is the problem with that in my experience, you see with multi-tiered arbitration agreements and with arbitration agreements, as my colleague was mentioning, drafting, unclear drafting and binding terms. And that jeopardizes something very fundamental, which is the enforceability of the word. And I've seen, you would expect this not to happen in sophisticated parties, sophisticated contracts, but it happens all the time. And it happens basically for multiple reasons. First, because again, I will blame always the corporate guys. But if we get serious, if you think about the contract, you think about the price, you think about the indemnities, you think about everything related to the contract. But then the dispute resolution provision, the way in which you're going to solve any problem with regards to the interpretation or enforceability of that agreement is not well thought. You end up with problems like we had a contract in which the parties foresaw that there were going to be a lot of disputes. Instead of setting something easy, like an expert determination, someone who would say, this is what we're going to do, and then you can go to arbitration, they set a negotiation period for every dispute of 6 months. A contract that was intended to be executed in 2 years took 10 years. That is not what the parties want, but it was a problem of drafting. Other problems we've seen, how do you avoid this problem? When drafting, remember, we are lawyers. Talk to the people who are going to execute the contract. Where do they foresee the problems are going to come? What are they seeing? Do they have experience executing these contracts? And where have they found trouble down the road? There, you will be able to backtrack and be more accurate choosing your multi-tier clause. Ask yourself a very simple question. Do I need this? Do we need a multi-tier clause? Because sometimes we just assume we need one. And maybe it's not the most beneficial thing for the contract. And the third thing that I think is key, besides proper drafting, is establish realistic requirements in those clauses. Like we were preparing the panel and I was telling them, one of my clients, we did not draft the contract, we get a dispute, it was a dispute board. And in order to constitute the dispute board, we had to find 3 people who had 15 years of experience in physics, 15 years of experience in chemical, and PhD in chemistry, and PhD in both. And we couldn't find people around the world that had those requirements. And that brought us back to the question of who agreed to this. And then the worst thing was, okay, but what are these guys going to say? Yes, it's a nuclear plant, but the discussion is force majeure. So what do people with PhDs in physics and chemistry know about that? So be realistic and try to like bring things to the ground, think about it, and avoid what typically is called midnight clauses. Give the same time tell your clients to give the same time they devote to discussing price and indemnities to negotiating the multi-tier clause.
Thank you. I just want to add really quickly, since we're analogizing this to marriage, when you start your agreement, you're friends, you're going to get married, you're in love. If you get a divorce, be careful, because sometimes these clauses can be used against you and can be raised as jurisdictional objections, which can delay your proceedings. So that could be good for you or bad for you, but be careful. So Liz, going back to the standard ICC arbitration clause, is there anything else that you would want to specify?
Yeah, so in practice, most of the contracts that I advise on or that I've arbitrated under depart from, or I should say elaborate on the standard form in one way or another. So in addition to specifying seat and language, drafters commonly add various bells and whistles to the clause. And I would group those bells and whistles into 3 categories. There are those that any well-advised party should always consider adding. There are those that well-advised parties should always resist the temptation to add. And then there are some that might be appropriate in certain cases, but require some careful thought. And then there's the middle bucket. Just running through those 3 buckets quickly. Starting with bells and whistles that parties should always consider adding to their arbitration clause. First of all, if the contract does not somewhere else specify that the law the arbitrators are going to apply, the arbitration place is a handy place. The arbitration clause is a handy place to include a choice of law. So if it's not somewhere else in the contract, it should be in your arbitration agreement. Second, you should give thought to, once you've identified the arbitration rules and the framework that you're submitting your arbitration to, you should consider whether it's appropriate in your circumstances to opt in or opt out of any special procedures that are provided under those rules. So for example, the ICC arbitration rules provide a mechanism for the appointment of an emergency arbitrator to hear urgent applications before the arbitral tribunal is constituted. And that can be an absolutely essential protection when it's taking a few weeks or sometimes a few months to get a tribunal up and running. Now, when this feature was first added to arbitration rules, there was initially some concern that the fact that there was an emergency arbitrator available to hear urgent applications would somehow impede parties' access to going to courts that might otherwise be available to hear urgent applications. The ICC rules attempt to deal with this by specifying explicitly that the availability of emergency arbitrators is not an impediment to parties accessing court remedies in urgent situations. But that's the kind of thing that you want to carefully understand if there's, and actually most jurisdictions have kind of come around to sort of settle down on that issue, but you'll want to just double check the position in relation to any court that might have jurisdiction or you might need to access jurisdiction for interim relief, whether that's an issue. And if so, you'll want to opt out of the emergency arbitrator mechanism. The other set of provisions that are commonly in arbitration rules and are in the ICC rules are provisions for expedited proceedings. Now, the ICC rules provide for expedited proceedings in cases that have a certain low, not low to me personally, but low in the grand scheme of international arbitration, amount in dispute, currently either $2 or $3 million. Now, if your dispute is below that threshold and you do not opt out of the expedited proceedings, you will be in the expedited proceedings. So you'll want to think about whether that is appropriate for you, is what you want. Similarly, you may decide that you want to tap into the expedited proceedings, even if your dispute is of greater value than the ICC decides is material. So you may set a different threshold for accessing the expedited proceedings or simply submit all disputes to expedited proceedings. So that's the second sort of thing you should always be thinking about in drafting an arbitration clause. Third thing that drafters should think about is whether the combination of the clause and the law of the seat and anything else in the contract provides them sufficient protection for confidentiality, or on the contrary, actually allows them to satisfy any transparency obligations that they're subject to. That's something I know Anne-Marie's going to talk about, so I'll leave that, but that's definitely on my always think about list. Have you got the right background set of rules for confidentiality or transparency given the nature of the relationship? And finally, on the must consider list would be any sort of idiosyncratic or particular language that's necessary to make a clause enforceable in view of either the place where you're going to arbitrate or relevant jurisdictions where the parties come from. So if you look at the ICC's website, for example, they tell you there some specific language that you want to make sure you use to make an arbitration clause providing for arbitration in mainland China effective, right? So there are those kind of unique local factors that you'll want to consider. So that's what I think people should always be considering. Turning now to the sort of proceed with caution category of bells and whistles, I would put multi-tiered clauses in a proceed with caution bucket, really for the reason that Mary-Kate was mentioning, which is that depending on how they're drafted and depending on what court is addressing the situation, in reality, they can be an impediment to getting to arbitration quickly in circumstances where everybody knows the case isn't going to be resolved and you need to get to before a tribunal more quickly. So not a never, but a think about it. Think about whether the relationship is one that is likely to result in an early mediated or negotiated settlement. So for example, I'm most commonly, or at least half the time, I'm dealing with contracts that have on one side a state or state entity and on the other side, usually a large multinational company. And they almost invariably have multi-tiered clauses. And those cases almost invariably do not settle until either after a hearing or right before a hearing. So that's one person's experience, but it seems like a situation in which the other thing I'll say about that dynamic is my clients in those relationships are never really rushing to arbitration. If they're going to arbitration, it's because they absolutely have to. And so the idea that they would need to be forced to do everything they could to avoid a dispute with the host state, it just doesn't really match the reality of the underlying relationship. But those provisions are really invariable in the contracts that I see. So that's one. Second, proceed with caution technique is split clauses, where the contract actually provides for multiple types of dispute resolution. And that can be absolutely appropriate in a given transaction or contract, but you need to be very careful in drafting split clauses that you're very clear about directing traffic. These types of disputes go to one mechanism, other types of disputes go to another. How do the two interrelate? Can one lead to the other? All of that just requires careful thought. A third potentially dangerous bell and whistle, and one that I might just put on the never ever list, is to impose a long stop time limit on the arbitration proceedings. It always sounds reasonable when you write it down, when everybody's happy and hasn't slept for 3 weeks because they're finalizing the deal. And it's always unreasonable and potentially prejudicial to the parties in practice when you're up against a really aggressive long stop date for concluding the arbitration. Final proceed with caution is really trying to get too prescriptive, in my opinion, about disclosure or discovery. And that's just for the simple reason that you don't know what you're going to want. And you might find yourself really wishing you hadn't, or somebody 10 years ago hadn't foreclosed a discovery technique that would really be very important. If you want to have a little bit more predictability about the procedural flavor of your case, you can make reference to bodies of sort of collected practice like the IBA rules on the taking of evidence or the Prague rules on the efficient conduct of proceedings in international arbitration that sort of sets a set of procedural expectations about how discovery will happen, but that aren't quite as prescriptive as, to say, there will or there will not be X or Y process. So two things that I would say, two particularly bad ideas in addition to time limits that parties should really probably never include. And that is making a sort of fudged compromise between either choice of law, sort of a hybrid choice of law, or a mixed arbitration agreement, hybrid arbitration agreement that mixes administering institution and rules. So what am I talking about? Classic example of a bad idea, or something what seemed like a good idea but turned out to be a nightmare, was the governing law clause in the suite of contracts that governed the construction of the Channel Tunnel between England and France. And the governing law clause in that set of contracts provided that arbitrators were to apply principles of law common to the law of England and the law of France. Well, of course, by the time lawyers get done with it, there aren't any principles of law that are common to the law of England and the law of France, not even, the most basic ones. And so it became its own separate ancillary fight about what is the law here, which is problematic enough once a dispute has arisen, but of course also is problematic when you're trying to actually live under the contracts before a dispute has arisen, right? It leads to unnecessary confusion. It will have seemed perfectly appropriate in that quintessential, cross-border transaction to just, we're all transnational here, but it proved to be quite problematic in practice. And then hybrid clauses submitting a dispute to be administered by the LCIA, but subject to the ICC rules. That creates a problem because the very institutions and ways in which arbitrations proceed under those different sets of rules are different. And you just can find an institution unable to administer according to a different set of rules. And then the final do not do is Jose's horror story, which is to have highly elaborated and mandatory requirements as for who should be your arbitrator. First of all, you might not guess right. In his example the dispute had nothing to do with the expertise that was specified. Or you may not be able to find the unicorn that you describe in your beautifully, carefully drafted arbitration agreement. So bottom line, where I come from on bells and whistles is really less is probably more. You want to be thoughtful about the ways in which you need to accommodate the realities of the transaction or the parties that you're dealing with. But you could really do a lot worse than to start with the ICC model clause and think about a relatively short list of key things: seat, language, anything really particular to the transaction, and leave it at that. Final point, I just noticed that the ICC model clause doesn't actually specify the number of arbitrators. And I think there's a good argument for that approach, although I will say in practice, I'm not sure I've advised on or seen an arbitration agreement that doesn't actually specify the number of arbitrators. I think it's maybe just too much of a control freak tendency by drafters, or just in my obviously anecdotal experience, a pretty universal instinct to actually pick 1 versus 3 arbitrators.
Wow, thank you. I think we'll all have nightmares tonight thinking about some of those things. Before we turn to confidentiality, which Anne-Marie is going to discuss, we actually have the most controversial topic that the panel found while discussing. And so I'm going to take an audience poll on this. And I want everyone who thinks that the parties should specify the number of arbitrators in the agreement to raise their hand. That looks like more than half. Okay, now who thinks you should leave it 1 or 3? Raise your hand twice. Yeah, you raise your hand. Okay, so now could someone from either side tell us why? Why would you specify 1 or 3 at the outset of the contract? And why would you maybe want to leave it open? Someone has to answer.
Helps the dispute resolution clause be more predictable
Which one?
by specifying the number of arbitrators, either 1 or 2.
Okay, so predictability. Anybody on the opposite side of the debate want to tell us why? Anne-Marie, would you like to tell us why?
Parties, when they're entering into this arbitration clause, have no idea what type of dispute it's going to be. Usually, again, you can of course have state parties, and there you're going to always see a clause with 3 arbitrators. But in a normal general commercial contract, again, you could have a very large contract with a very small dispute, and you could have a small contract where the dispute becomes very important for the type of party that's involved in it. And I think, again, having seen myself several contracts where the number is not specified, the parties, especially if they're in an institution like the ICC, trust the institution to determine the correct number based on the type of dispute that actually happens. So the ICC court, if the parties can't agree on the number, will decide the number, and the ICC court will get it right. It will know whether there should be 1 or 3 arbitrators. Now, the other real reason is I've personally seen those clauses where parties will say 3 arbitrators, and then when the dispute occurs, one side defaults, one side doesn't show up, and the party who wants to go through with the dispute has to pay all the costs because there's a non-participating party, has a huge burden on them, has 3 arbitrators for a dispute that, again, could be handled much more efficiently with a sole arbitrator and no one on the other side. So again, I think it really has to be decided on a case-by-case basis, but I would never say that you should always determine the number in the clause. There are cases where you should do it. There are cases where we know it's going to be done because of the type of parties that are involved. But for many general commercial contracts, you may want to keep your options open.
Imagine having a case where it's unpaid invoices, $100,000 in dispute, and you have to pay for 3 arbitrators. It's a nightmare. So I'm on Anne-Marie's side and with the minority of the group. So, okay, before we go on to confidentiality, this is actually a question about confidentiality. Who thinks arbitration is inherently confidential? Raise of hands. I won't make you say why. Okay, so everybody that thinks it's not inherently confidential. Okay, great job. Now, Anne-Marie.
I think those are some of my students who got the right answer. Again, yes, maybe some people do have that assumption that all arbitration is confidential. And first, again, we have to distinguish what type of arbitration are we talking about, because there's a big difference between investment arbitration and commercial arbitration when we want to talk about this topic. But if we look at commercial arbitration now, the situation is that it truly depends. Most national laws do not have specific provisions dealing with confidentiality. There are some, and I know right now the English Arbitration Act is under revision, and there is discussion of having those confidentiality provisions put into the law. But there are, and Hong Kong is another example where there is a confidentiality provision actually in the law, but most laws do not have specific provisions. And so again, it becomes very important for parties to know what they want. For some parties, they don't really care whether the arbitration remains confidential. Maybe some of them want it out in the public, and they believe for reasons of transparency, et cetera, it should be in the public domain. Other parties honestly think that confidentiality is one of the reasons they're going to go to arbitration. And if you look at many of the surveys and studies that are done, such as Queen Mary, et cetera, confidentiality always comes in as one of the reasons parties want at least commercial arbitration. So confidentiality is important to you. You need to take care of it. Now, you can do that in your arbitration clause by having some reference to confidentiality. I'd say it's probably more common to have a full confidentiality clause in the contract that will also cover the arbitration. And if you don't have it in your contract, then at the time of the dispute to ask the arbitrators for a confidentiality order, or for the parties themselves to agree, have a confidentiality agreement that they enter into. But when you're drafting your arbitration clause, you definitely need to think, do I want to have confidentiality or not? And on the other side, if I don't want confidentiality, because in some places it may be assumed or it may be required by the law, then you need to specify that as well. The other thing I want to say about this is it's not enough to just say confidentiality. Right? You have to be very specific about what will be covered by those confidentiality requirements. So the very existence of the dispute should be confidential. The documents that will be produced, that will be obtained from the other side, not just the documents that will be introduced into the arbitration. Any procedural decisions, the awards that will be rendered by the arbitrators, and not limit yourself to the arbitration, but think about what about the court proceedings that may be required for enforcing or setting aside the award. You want to think about the people that are going to be involved. And again, it will be more than just the parties. So the parties, the counsel, the arbitrators, experts, witnesses, all of these people that may, institutions that may have access to information, you want to be very specific about how confidentiality is going to affect them. And then you have to take into account the limits that may exist, because we can all say we want it confidential, but they're going to be mandatory requirements under national laws for some information that may have to be disclosed, or for the parties to be able to pursue their legal rights. Or, for example, if information is already in the public domain. So you have to think again about what will be confidential, who's covered by this, and what are the limits on that confidentiality.
And I know confidentiality was something we talked a lot about at the ICC a couple of years ago, because I think, Anne-Marie, wasn't there something that the ICC started doing maybe back in 2015, 16, 17?
So because again, the ICC handled mostly commercial arbitration cases, although when we say commercial, that could still involve state parties, and a large number of ICC cases do have state parties. The ICC cases were confidential, were treated as confidential, definitely by the institution. And so the question became, what happens to the awards? and whether the awards should be published. And there has been a huge evolution in this area where now the ICC, at least, the process is that awards will be published with information unless the parties opt out. So this is, Liz mentioned this idea of opting out. What institutional provisions do you need to think about that you might want to opt out of? So if you do not want your award to be published, you need to opt out, because the normal process will be for it to be published. Now, so you can do that now in your clause or in your confidentiality provision. But you should also know the way the ICC works is that they're still going to ask the parties, this is the insider story, they're still going to ask the parties in the arbitration, is there any objection to the award being published? And so you're going to have that asked to you up front when the proceedings started. You're going to have it asked to you when you get to the end of the case. And Marek can confirm, you're going to have a 2-year period after the case where they're still not going to publish. So you could still raise your objection during that time period. So something to think about for your clause publication, but you've got a little bit of time afterwards if you still want to opt out. Now, some people may think it's great that there's all this publishing. Other people, it's very important for them that the award does remain confidential. And so then you need to think about that for your clause.
Yes, and I will mention that there is a new model clause on the ICC website, which does address the publication of awards. And you will be asked in 1,000 ICC letters from the Secretariat whether you agree or not. So yes, you'll have plenty of occasions to object or agree. Our next poll is, who thinks the awards should be published? Who thinks they should not? Okay, that's not 50-50, but Jose, can you tell us, how do you handle your client? How would you discuss this issue with your client if you're drafting your arbitration agreement and it's known that, you know, any award that may come out in any dispute that may happen may be published?
So the good news is down the road, typically you don't discuss this with your clients, let's be very honest. You discuss multiple things, as Liz was explaining, but I don't think I have ever actually discussed confidentiality, including a confidentiality provision. I have included ICC provisions, and I know they will ask me, and Marek will tell you they will send you as many letters as they need for you to consent. And at a certain point, you will be like, yes, we consent. Another practical tip, if one party disagrees, they won't publish, which that gives you leverage down the road and flexibility in the sense that you don't have to decide this upfront. But I think I think it was Liz who drew an important difference. There's ISDS, there's investor state arbitration, and there's commercial arbitration. And I think the fight for transparency and the more the need for more public awards and more information is being pushed more in the investor state arbitration than in the commercial arbitration. There has been a push, and the ICC has done it for commercial arbitrations and other centers. But I think, and I'm going to use a word that people don't like, this paranoia of transparency is more focused on investor state. And it's more due to conflicts and to the idea that you want to have predictability. So while talking to the client, these are not things you're going to tell him. Well, let's agree to a confidentiality agreement. Why? Well, maybe in 10 years, there will be 4 cases of the arbitrators we choose, and you will have predictability. It's not realistic. When you discuss confidentiality with your clients, you discuss it based on reputation, who the other party is, and how you may think that things will unfold. Because if you're going to lose, your client is not going to want this to be public. They will want it to hide it under a rug. And the only way it becomes public is if the award is enforced. So there's a strategic decision to be made, but typically, at least in my view, this is not something you discuss. And again, there are arguments for, would I want awards to be more published? Well, there would be more foreseeability. I would know there would be more predictability of outcomes. I would know better how to choose an arbitrator more than in like what we call the telephone strategies. Call your friends and ask them what do they know about this arbitrator and how has he resolved in other cases. Would it be better not to have to do this? Yes, but Anne-Marie cited the study of Queen Mary. If I recall correctly, that study said that the second thing that parties valued most of arbitration was confidentiality. So that is still in the brain of people when agreeing to arbitration. And it's a very relevant issue to agreeing. And I can definitely tell you, most of my clients get this question wrong. They think arbitration is confidential per se, even investor-state arbitration. And when you go to free trade agreements, when you go to certain mechanisms, those mechanisms include transparency requirements, and clients don't know that. They are surprised by it because they are like, well, but then I would have gone to a judge. It's like, well, that's not the difference between arbitration and court litigation, but the rules, like everything, are amended by the agreements of the parties. And if you don't agree that something's confidential, unless the rules that you've applied provide for confidentiality, it won't be. So tell your clients.
Sorry, I have a question. So how do you reconcile these confidentiality agreements and your preference of the clients with the double heading that you might have, especially if you are lawyers from Europe? And as lawyers, you are also gatekeepers, and you have to comply with MLA rules. And there's a global prohibition order against MLA. It translates in the Latin principle ex oritur action non exculpi causa non oritur actio. So what is produced by fraud cannot produce any results. And that means that, we should have started this discussion not with how many words you need to enforce an arbitration clause, but how many parties do you need to produce to have an arbitration hearing? Because in terms of beneficial ownership, you can have two parties. Let's say one party established in a country and one party established in an offshore, which is an affiliate of the subsidiary or an alter ego of the same party. So they establish the same beneficial ownership, establish a contract. You pretend not to perform the contract, and you refer this to arbitration. And these are laundromats. They are machineries to launder money. So we've seen it a lot in the last years in litigation. And some of you, maybe here in America, the Corporate Transparency Act does not include yet lawyers as entity reporters, but the global regime against money laundering designates lawyers, or they should at least designate arbitrators as subject who may be compelled to report red flags of money laundering. So when you are dealing with these 5 million, or I'm not sure, large disputes, you should be able to comply, because this is a public order regime. So you should be able to comply with your obligation under the MLA, under the FATF standards. Thank you so much.
Do you want to take it, Ms. A?
Please, Liz.
I'm certainly not an expert on money laundering regulations, although I have operated in jurisdictions where lawyers are required reporters. I think the way the arbitral regime tries to deal with that problem is by imposing an obligation on arbitrators, essentially themselves on their own initiative, if they become aware of circumstances that suggest there's fraud or illegality, to raise the issue. Right. So there, it's not so much that confidentiality might create a situation in which others wouldn't be scrutinizing what's happening in the arbitration, but there's a very clear duty on arbitrators to have an eye to public policy considerations. This was established most clearly probably in cases involving anti-competitive behavior, but the same principle applies to other kinds of illegality or fraud that becomes, arbitrators are under an express duty not to turn a blind eye to those indications, and whether or not they're subject to the regulatory regime is something I'm not an expert on. Others in this room will know better whether that's because or there's a sanction in terms of AML regulations, but from the perspective of an arbitration practitioner and the perspective of what happens in the hearing room, even if the doors are closed, the way the system attempts to meet that problem is by imposing a duty on arbitrators to be alive to those issues and not to participate in essentially endorsing a fraud.
Yeah, and I think there are two backstops, taking Liz's glove. The first one is don't undervalue the reputation of arbitrators. Arbitrators are not there to pay to play. The reputation of an arbitrator is all it has. One case goes rogue, there's no more appointments. His reputation in the market is tarnished.
Sorry, I don't value the reputation. I value the training in certain areas.
I did not copy that.
I don't challenge. I respect your reputation, but I'm afraid that there are new typologies of money laundering, and there's no specific training in this area for arbitration. So this is my main concern.
There you have, then you maybe chose the wrong arbitrator.
Oh, I'm sorry.
Oh.
I was just going to say, I think from my experience, when there has been fraud, that award usually becomes public because somebody is going to take it to a court. And so the issue of confidentiality becomes null because it's in front of a court. But Marek, take note, good ICC training on fraud coming up next year. So thank you for your question. Before we move on, does anybody else want to talk about why awards should or should not be published? I don't think they should be published.
Can I just throw one factor on the pile for consideration? I will say most commonly my clients will expect that their arbitration will be confidential and will value that in the way that all of the surveys report. But just to put another point, or put the point a different way, there is a case to be made that there are areas of law where disputes are so uniformly submitted to arbitration for resolution that there is essentially a vacuum of publicly available information about how the law in that area is developing. And I'm going to get the name wrong, or I'm going to forget the name of the English judge who very poignantly made this point, right? That there are areas in shipping or insurance where all of the disputes are arbitrated. And we have essentially decades where we don't have any judicial decisions construing standard form contracts or construing, other so we talk about predictability. We talk about parties wanting to be able to organize themselves by reference to what does this language actually mean, and you can have a vacuum of information. So I think that's one of the significant arguments in favor of finding a way to make available in a way that is consistent with parties' expectations. Yeah.
I think that is, I remember it was the English lord who said that arbitration was killing the development of law. And I think we have to come back to what is the purpose, especially of commercial arbitration, and should a commercial arbitration be there to advance the law, or should it be there to solve commercial dispute between two parties? And so I'm very sorry that parties want to go to arbitration to have their dispute between them resolved, not a common law system where we're creating precedents that we should be seeing applied in future cases, but no, solving this dispute in the most efficient economic way. And so I was not at all touched by the poor judge's concerns that English law is dying because of arbitration.
But it also reflects the supremacy of English law in his mind, because if you think about it, that doesn't apply to European law.
Right. No, the common law system. Right. Yeah. Sorry.
We're Europeans.
I was going to say, I'm sure we have some European audience members who know the difference between res judicata and non-res judicata.
I'll just add something very quickly. Just in terms of the debate about publication or non-publication, remember, it's not one or the other. There can also be publication with anonymization, right? So it's not really one or the other, as a choice. There is a way of protecting that confidential information that you don't want to be out there, while at the same. So I think a lot of these goals can be accomplished through that process, and hopefully, as time goes by and as these awards are online, people can see them, see how they look, And from there, maybe what we'll see is even more awards being published because they will feel comfortable with that anonymization and pseudonymization process, that everything that we've been debating can actually be accomplished. But we'll see, time will tell, but we're seeing a slow march toward that, but it'll take a few years before we know whether this is actually going in the right direction.
Thank you, Merrick. So just before we get to our last and most fun topic, I just want to remind everyone that there is a difference between institutional and ad hoc arbitration. And this is important when you're dealing with your arbitration agreement, because those institutions, and as someone who still has my little ICC flag with me at all times, those institutions are there to help you in the event that there is something wrong with your clause. So as was mentioned earlier, the institution can determine the number of arbitrators. The institution can appoint an arbitrator on behalf of a non-participating party that can fix the place of arbitration. They take care of the finances. And so that's also something to consider when you're drafting your arbitration agreement is, do you want an ad hoc arbitration or do you want an institutional arbitration? And I think that the ICC rules provide a lot of safeguards against having what we are about to talk about, which is pathological arbitration agreements. So for the next 2 minutes, if everyone can kind of, just talk to your neighbors, you have a little notepad and a pen, and look at these clauses and come up with what's wrong with them or how you would fix them or some type of advice, that would be great. So thank you. Yeah, that's the only thing that I can come up with. I yeah, good luck getting any document. Hello, is everybody ready? Would anybody like more time? Raise his hand. All right. So who is brave enough to talk about clause number 1? Oh, we actually.
I think for the first one, it gives the provisions for both, but it doesn't say when would we go for arbitration and when will we go for litigation. It's just giving both the options, but when is which applicable, it doesn't say that.
Yeah, so what it results in is not an unequivocal submission of disputes to arbitration, right? It's like, well, we could do either.
And if I may, Liz, you would be surprised how many clauses like that you see.
Yeah.
Particularly when people start getting fancy with unilateral option clauses.
Yeah.
You have huge problems because multilaterals typically will want a unilateral option clause, but I don't know who drafts them. but you will see clauses like that in separate clauses of the contract. So you need to reconcile the contract, which are absolutely incompatible.
Yeah.
So it's not a theoretical problem. This really exists.
No, and if there's not a clear intention to arbitrate in the courts, they're going to find this is not an arbitration clause. So the party that wants arbitration has lost the right to go to arbitration here.
Probably because the courts of England think that the ICC is French, so they're going to enforce it.
Yeah, same with Delaware. Okay, number 2, the second one. Who wants to talk about that one? Okay.
There is a clear intention to arbitrate, but the arbitral institution seems to have been specified wrong. I'm taking a guess it's LCIA here. Mentioned as CIA.
Okay, sorry, can you say that again in the microphone for our listeners at home?
So there appears to be a clear intention to arbitrate because it specifies all dispute to be resolved through arbitration. The by the CIA is something that is not necessary for the intention to be designated. So the arbitration clause ideally should survive at home.
Mhm. And you also said that it seems like that would be the LCIA.
Yes.
Yes. However, who knows?
Because it could be a translation from the French or the International Court of Arbitration, the Cour Internationale d'Arbitrage, which would have been the ICC.
Or ICSID in Spanish. With 2 pending lists.
Yeah. So
But there are very
now
often
you're
translation problems in clauses where the name of the institution doesn't get translated properly.
do you want to tell us what you do since we have a second? What would you do with this clause? Would you go to court? Would you arbitrate?
We'd arbitrate, but probably the parties can either renegotiate on the institution or submit the dispute to court to decide on the institution.
Okay. Yes.
Thank you. But I'm not sure, and I would like to hear the panel about that there is a clear intention of arbitration, because the words there don't say all disputes are to be arbitrated. They say all disputes that to be resolved through arbitration will be held or will be before the CIA. So if you consider that with the first line, is not saying, is not, to me at least, at first glance, is not conveying a clear intention to arbitrate. Really. I don't know what do you guys think?
Yeah, I can see that.
I mean, I think that's a plausible reading, and I think you'd find yourself in a debate about whether that was the better reading. Because in context, all disputes to be resolved through arbitration by the CAA is read more naturally as all disputes comprehensively are to be resolved through arbitration by the CIA, rather than any disputes or disputes that are resolved by arbitration should be resolved by the CIA. I think you have to do more blue pencil work to get to the second interpretation than to the first. But, you know, this is not where you want to be with your arbitration clause. That's the takeaway here. This is not where you want to be. You don't want to be having that debate.
But thank you. That's very interesting because that is what happens in practice. Okay, the third one's a little long, and I believe that this was an arbitration agreement that may have been submitted to an institution. So what's wrong with it?
They didn't come to do this.
All right, Liz, would you like to tell us what's wrong with it since we are running out of time?
Well, others might have better views, but I'm just not even sure what it means. The first sentence, okay. The second sentence, any matter of dispute and which is not provided for, presumably in this agreement, shall be submitted to arbitration under the provisions of the Knoxville, Tennessee statutes. Okay, putting aside the reference to Knoxville, Tennessee, I have no idea what that even means. It's not clear that they're submitting all disputes, but only disputes that are not provided for in the agreement. So it's frankly just such confused drafting that I would have a hard time working out what they actually meant to say. And then I don't know whether Knoxville, Tennessee has enacted statutes in relation to the arbitration of disputes. Maybe it has, in which case, yay, Knoxville. But it's just, there's, again, not really where you want to be. And did any of you guys ever dealt with this? I mean, is this like a real clause that?
I believe this is a real clause.
I'm sure it's a real clause, but is it one that any of us has personal experience of?
Someone. The last one,
Are you bound by confidentiality, or can you disclose what happened there?
The last one is actually from something I had to deal with. So what's wrong with the last one? Yes. Oh. No, go ahead.
So I guess it says shall be finally settled through arbitration, Southern District of New York, but doesn't really specify, which institution. Southern District of New York is just a venue. So there's no real explanation of how, as in, what will be the arbitration mechanism. I guess there's a clear intention to arbitrate, but really nothing beyond that.
We have another opinion.
For me, it's not very clear if they want arbitration, because when I saw Southern District of New York, I was thinking about the court. So I'm puzzled there. The last 5 words of the sentence, I don't know if they want arbitration or not.
Yes, thank you. I can tell you that when you saw this clause in the contract, it was a clear copy paste and someone forgot to delete a word or a phrase. So unclear if they forgot to delete arbitration or the reference to the Southern District of New York, which would have been, the exclusive jurisdiction clause. So does anybody have any questions in general? I believe we have reached the end of our time, but
would it be like ad hoc arbitration, which like the hearing, the place of hearing is and they subject to the Southern District New York to just the intermeasure, something like stuff.
It's a good argument you can make. Yeah,
I think it could have been the supervising authority that they mixed, and I don't think Southern District of New York is seen as a geographic location. I mean, it's when lawyers hear it, at least it's the federal court, but
yeah. I did change the name of the court so you couldn't figure out who this came from, just in case. Yes.
So my question was with regards to.
My question is with regards to confidentiality when it's not mentioned in the agreement and the parties are not able to come to a consensus they want to publish or not. So do they actually have to present arguments for and against, or how is it decided in that scenario?
You just send an email to the secretariat and say, we do not want this published.
So favor.
Yeah.
So the favor is given to it not being published.
Correct.
Correct.
And there will be many, many, many paragraphs and many letters that will explain to you how to do that.
But regarding the same point, what if the parties did not opt out and the rule is it is not confident? Sorry, it's not gonna be confidential if you don't opt out. And then, so why does the rule exist if at the end of the day I can just oppose to just saying no, I don't want it published, although I did not opt out? So what is the rule for? Kind of like a question for ICC maybe, but what does the panel think?
Probably what I would tell you is Alexis Moore would love your comment. But unfortunately, that's how it is. There's no rule in the rules. The ICC will always ask you. And if one party says no, it's no. And there's a big push for publication. And I think the ICC is doing the right thing. The ICC always does the right thing. But there's an argument to be made that if you didn't opt out, the rules are clear. They don't say anything about that. So it's not confidential. Screw you.
I think you could also get in a lot of situations, and the preference of the ICC, I would think, speculating, would be that they want awards to be published. And with a lot of non-participating respondents, if you had just an opt-in system, you would probably not get a lot of awards published. And so that is why I think it's very important to underscore the fact that you can now put in your arbitration agreement that you do not want your award published.
The other point to make, and this is, it's that of course, like all of us in this room probably, or maybe not the students, but the ICC is an institution that's offering a service, and they need to stay sufficiently attuned to the expert, and we all throw our hands up saying we think our clients would want confidentiality, would oppose publication. I imagine the reason there's not been an, instant draconian imposition of a black letter interpretation of the rule is because they realize that mindsets are changing and it requires a little bit of time for people to become attuned to that. And a bit of testing the waters to see whether this is something that is an attractive feature or is something that is a problematic feature. That would be my utterly uninformed guess about why the practice is not as, guillotine-like as it might be.
Oh, okay.
One more question.
Last question.
Thank you. Just a short question. Do you think that the decision about the costs of the arbitration should be included in the arbitration clause?
It depends what you say, because again, people don't listen enough to list, and the problem you see all the time is they include concepts. A cost shall be paid by the prevailing party. What does that mean? If there are 10 claims and you win 5, are you the prevailing party? Are you not the prevailing party? The ICC rules already deal with that and give discretion to the arbitrators. My opinion is it's better for the arbitrators to deal with that when you're negotiating a contract to decide how costs should be allocated.
Wholeheartedly agree.
I agree that you again, the fallback under the rules is the discretion of the arbitrators, and costs can be an important power for the arbitrators to actually sanction party behavior. And I don't think that should be taken away from the arbitrators. They should have that power to put the costs on parties that have made the proceeding heavier, that have not complied with orders from the arbitral tribunal. It's an important power of the arbitrators to use costs.
Okay, and Ken gets the actual last question because he's a partner here. So
Well, I just want to comment on the cost issue. I think that's a good question. It's not often addressed, unfortunately. But given that the cost following the result used to only be a UK concept, and the US has a quite contrary presumption. But now with investment arbitrations, it's becoming almost the universal rule in investment arbitrations. And so I think in commercial agreements, there often could be some misunderstanding as to which general rule is going to apply. Is it going to be the prevailing party is going to get costs allocation at the end or not? And I think it's important because it also affects who brings claims. Because if you only bring claims, if you think you're going to win, then maybe some of the spurious claims would not be brought forward. So I do think it has a benefit in adding it to your clause.
thank you. And thank you everyone for being here. There's still drinks. I think there's still food. I don't think we're kicking anyone out. I don't actually know what time this ends. So thank you. And I hope everyone learned something and you have all of our names. So if anybody has any questions and we don't get a chance to chat, send us an email. I'm speaking on behalf of everyone. And it was great to see all you. So thank you.
Yeah.